Fraudulent misrepresentation is the next possible type of defense that a party can raise to avoid enforcement of a contract. This applies where one party induces the other party to enter into a contract through fraudulent misrepresentation. If the defense is raised successfully, the result is that there is a lack of genuine consent and the defrauded party may avoid the contract. The 4 elements of fraudulent misrepresentation, all of which have to be proven, are as follows. There needs to be a false assertion or omission of material fact by one of the parties. The assertion has to be made with scienter, that is, an intent to deceive the other party. The assertion needs to have been reasonably relied on by the other party. And such reliance must have caused harm or damages. Let's look at an example. Carl wants to invest in a theme park in California. Bobby, the owner of a park that focuses on extraterrestrial life, Martian World, is interested in selling his park and invites Carl for a visit. In order to impress Carl and make the park look much more popular than it is, Bobby hires 4,000 actors that pretend to be visitors at the park. Carl likes what he sees and signs a purchase agreement 1 week later. Would this amount to fraudulent misrepresentation? It certainly might. The presence of the actors is a false assertion. From the facts, it sounds like Bobby acted with the specific intent to misrepresent the number of visitors and to deceive Carl. We can't tell whether it was reasonable for Carl to accept what he saw or whether he needed to dig deeper. But assuming he reasonably relied on the impression given during his visit, and further assuming that he would suffer a financial shortfall because he bought a park without sufficient visitors, there would be a strong case for fraudulent misrepresentation. An important question in the context of fraudulent misrepresentation is whether the parties to a contract have a duty to disclose certain information, including defects of an object that is being sold, during the formation or negotiation phase of the contract. The general principle is that of caveat emptor, Latin for buyer beware. Under this principle, the seller doesn't voluntarily have to disclose defects or other material information unless the buyer asks. Historically, under the common law, the buyer always had the duty to inspect, and the seller had no affirmative duty to disclose information about the subject matter of the contract. If the buyer failed to make a reasonable inspection before entering into a contract, and a defect is subsequently discovered, then a failure to disclose would not constitute fraudulent misrepresentation on the seller's part. More recently, however, buyer beware is said to mean that a duty to disclose arises if there is a material defect that the seller is aware of and the defect would have been difficult to discover even if there was a reasonable inspection. This provides the buyer with some more safeguards. There are also in several U.S. states statutory provisions that provide for a positive duty to disclose material facts in certain areas. This includes, for example, contracts between clients and their real estate brokers. Accordingly, a broker would have to disclose important defects of a house that the broker is aware of, and the prospective buyer would have difficulties in discovering even upon a reasonable inspection of the house.